that Bruin is a thing from which the public must be protected. This is simply not true.
Weim says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a federal agent.
Get on the ground!
But then it released him, apparently believing that a civil restraining order instead of pretrial detention was the best way.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
The Supreme Court will soon consider whether to hear an appeal of a ruling striking down domestic violence law under the Second Amendment, anti-subordinating the Second Amendment. The Supreme Court has once again reshaped Second Amendment protection in New York State Rifle and Pistol Association versus Bruin, invalidating a New York law that required proper cause to obtain a license to carry concealed firearms. This decision grants individuals a right to carry firearms in public, a change from Heller's grant of individuals a right to possess a gun at home for self-defense. The Bruin Court opted for a value-neutral approach, focusing on text, history, and tradition to determine whether a particular gun regulation passes muster under the Second Amendment. The court found that the New York's regulation was inconsistent with history and tradition, making it constitutionally invalid. Racial justice claims for gun rights have been present since the very beginning of the modern Second Amendment social movement and jurisprudential evolution.
June of 2021, you changed the department's asylum rules so that it could apply to individuals with significant gang violence.
Most apparent here a defense of the Second Amendment, which this most certainly is.
Weim says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles, Boston, and New York City.
As many of you out there, either parents, relatives, and/or victims yourself,
To do anything about what the president is doing to exercise that authority unconstitutionally, as was the case with student loans.
Because people buy hundreds of guns legally and then they sell them illegally.
As gun rights advocates turn to courts to enforce new, more expansive readings of the Second Amendment, they brought these racial justice claims with them. The same racial justice arguments asserted by gun rights activists in public fora in the late 20th century were transformed and made legible in former jurisprudential settings in the 21st century. The invocation of race in the modern Second Amendment debate has been asymmetric. Pro-gun conservative legal academics have amassed a war chest of scholarship advancing variations of the claim that gun regulation has racist origins and effects, while progressive legal scholars have largely remained silent. With the recent boon for the public defender's brief, conservative gun rights activists have successfully popularized the claim that gun control is racist after half a century of social movement mobilization without comparable resistance from progressive gun regulation advocates. In Bruin, the court expressly aligned itself with the social movement that has mobilized to change Second Amendment understandings on race-based reasonings. The note presents a counter-jurisprudence in the form of a competing normative framework that defends gun regulation as essential to addressing forms of racial subordination. This framework views an absolutist and historical account of the right to bear arms, exemplified by the Bruin decision as incompatible with the demands of racial anti-subordination. Anti-subordinating the Second Amendment requires making room for communities' interest in enacting gun regulation to attain conditions of equal public safety. This vision of the Second Amendment has historical roots in the civil rights mobilization against gun violence that spanned the 1990s. Civil rights organizations have made combating gun violence a national priority on racial equality grounds, recognizing that guns can be tools of self-defense and sources of communal subordination. Under this framework, the Bruin decision is subordinate, calling into question virtually everything about our current gun regulation schemes and rendering black communities less safe. The result is a Second Amendment jurisprudence that further deprives black communities of the capacity to secure for themselves the conditions of equal public safety.
Inventing the pistol stabilizing brace to help his friend, a disabled combat veteran, at the shooting range.
You gave testimony that the brave ATF agents are the ones showing up at 2 in the morning after a burglary.
Do any of my colleagues on the other side of the aisle give a whit about separation of powers?
Connecticut delegation, which is incredible. I think on this issue and many others, you're the best delegation in the United States.
No guns were lost. They were stolen by an individual who's now in prison.
And of course, we've got a lot of criticism over this. So why is it not a machine gun?
In areas that are poor, mostly minority, there's a mass shooting.
Congress wants to change the law and come up with a new interpretation, then ATF will follow that new interpretation.
The note proceeds in 3 parts, tracing the evolution of racial justice claims in the social movement history of gun rights activism. It also presents a normative framework for anti-subordinating the Second Amendment, arguing that expanding Second Amendment protection hampers communities' capacities to combat gun violence that exasperates social inequality. The note also takes an internal and external perspective on the law to understand the interplay between popular mobilizations and formal legal meanings. To understand what courts say about the meaning of the Second Amendment today, we must also understand how ordinary people have asserted and justified their right to bear arms in the past. United States versus Rahimi. The question that is being considered in the case United States versus Rahimi, docket 22-915, which is now being heard by the United States Supreme Court, is whether or not the Second Amendment to the United States Constitution grants the federal government the authority to prohibit a person who is subject to a domestic violence restraining order from carrying a handgun.
That Bruin is a thing from which the public must be protected. This is simply not true.
So other families will not have the experience and the pain and trauma that they had to live through.
For too long, states like New York told millions of citizens that their right to armed self-defense ended the moment they left their homes.
She proves you can run for office ending gun violence in the South and you can win.
Lawful gun owners are not the driving force behind criminal gun violence, and this is particularly true of concealed carry permit holders.
AK-47 is an automatic Kalashnikov model of 1947.
At the same time, as I outline in much greater detail in my written submission, they play a significant but underappreciated role.
You can prevent the next tragedy. You can save life. You can save families in the process.
It was a consequence of a decision made in 2023 by the United States Court of Appeals for the Fifth Circuit, which overturned a federal regulation that had prohibited individuals from possessing firearms while they were subject to a restraining order based on allegations of domestic violence. The outcome of the New York State Rifle and Pistol Association Incorporated versus Gruen case, which was heard by the Supreme Court of the United States in 2022, was a decision that led in a change to the way lower courts read legislation pertaining to the Second Amendment. Instead, then looking at the history of the Second Amendment and its breadth, the test that was outlined by Justice Clarence Thomas calls for a gun-related legislation to be consistent with the nation's previous gun regulations. This approach also calls for the use of intermediate scrutiny in the event that the first standard is ambiguous. This viewpoint contends that statutes must have historical analogs to laws that were enforced at the time of the adoption of the Second Amendment in 1791, or incorporation by the 14th Amendment in 1868. These dates are 1971 and 1868, respectively. Zaki Rahimi was awarded a civil restraining order by a state court in the state of Texas on February 5, 2020.
Yes, good faith applications of Bruin will likely result in some favored gun control laws being struck down.
Thought it just like, wow, it doesn't fit the definition, it doesn't fit the rulings, but we better run this up the chain.
To the extent that Bruin threatens certain laws, however, these are generally laws that weren't very good at protecting the public in the first place.
Some months later, during an ATF audit, I was told the background check was now a non-approval.
At the same time, it's undeniable that Bruin does not threaten many of the laws that are most effective at protecting the public.
Because they like the outcome of the policy, the banning of a piece of plastic.
Post-Bruin challenges have succeeded in lower courts. The opinions and reasonings therein have been grossly mischaracterized.
Obviously they're gone, but will be an inspiration for us to do more. I'm not going to sign this bill into law.
Circuit decision in U.S. v. Rahimi is worth highlighting. As others have noted, the panel struck down a federal statute.
I don't have a gun, but I don't give a damn about anybody else having one.
The order was issued in response to allegations made by his ex-girlfriend that he had abused her. The injunction prohibited him from owning guns and from engaging in certain acts that could be construed as harassing his ex-girlfriend or the child she was carrying. When police executed a search warrant at Rahimi's apartment because they felt he could have committed a second crime, they found a rifle and a pistol that Rahimi had acknowledged owning. The search order had been issued because police thought Rahimi could have committed a separate crime. A federal district court found him guilty of unlawful firearm possession under U.S. Code Section 922G8, which prohibits anyone from owning guns if they are, quote, subject to a court order that restrains them from harassing, stalking, or threatening an intimate partner, unquote. He was charged with violating the statute and the court found him guilty.
The most serious readily provable offenses in cases where mandatory minimums are present because it's not warranted.
Giving domestic violence abusers a license to kill and essentially preventing the government from doing anything at all about it.
What changed is that that item that was submitted was not produced and was not the item that was marketed.
The defendant there, Mr. Rahimi, is a despicable cretin that no sane, sober, moral, or prudent person truly believes should own guns.
To be able to assist those that might not have full use of all of their limbs or whatever else.
He violently assaulted his girlfriend, threatened to kill her, and shot at a bystander who witnessed the assault.
So you say that the brace changed, and so you had to implement this rule.
The government quite properly charged him with several crimes.
Sensitive places doctrine was not at issue in this case, and still exists.
But then it released him, apparently believing that a civil restraining order instead of pretrial detention was the best way.
He went on to say he looks forward to a quick resolution in the Texas Senate.
Predictably, Mr. Rahimi soon thought, to hell with your restraining order.
Who are prepared and carry a gun oftentimes have to make split-second decisions.
Aggravated assault with a deadly weapon against a different woman using a gun that he wasn't legally allowed to own, but obtained anyway.
Legal proceedings. Rahimi submitted an appeal of his conviction to the District Court of the Northern District of Texas using the Second Amendment as the basis for his challenge to the constitutionality of the United States Code Section 922G8. Following the dismissal of his suit by the lower court, Rahimi appealed the decision to the Fifth Circuit Court of Appeals. Initially, a panel of the Fifth Circuit upheld Section 922G8.
That requirement for showing a heightened need for self-defense, that was the teeth of these permitting laws.
And within less than 15 minutes, you can walk out the front door here with a rifle or a shotgun.
American citizens in places like New Orleans and Baltimore and St. Louis begin to seek asylum in countries like Honduras and Guatemala.
I don't know if you're referring to any particular incident.
However, Rahimi's request for a rehearing was still being considered when the Supreme Court handed down its decision in Bruin, prompting the Fifth Circuit Court to reverse its conclusion. The parties to the case submitted supplemental briefs and re-argued the issue in front of a new panel of 3 justices, 2 of whom were chosen by President Donald Trump and the 3rd of whom was chosen by President Ronald Reagan. The Fifth Circuit Court of Appeals declared USC 922G8 unconstitutional on February 2, 2023, preventing it from being applied in Texas, Mississippi, and Louisiana. On March 17, 2023, the Justice Department of the United States filed a petition with the Supreme Court asking it to reverse the appeals court's ruling and uphold the federal statute that makes it illegal for those who are subject to domestic violence restraining orders to purchase firearms. Opinions of the Fifth Circuit Court. Using Justice Amy Coney Barrett's dissent in Cantor v. Barr, which she wrote while serving as a judge on the United States Court of Appeals for the Seventh Circuit, Judge Corey T. Wilson rejected the government's claim that the Second Amendment only applies to law-abiding, respectable citizens in the unanimous panel's February 2nd opinion. It was Justice Barrett's position that founding-era legislatures did not strip felons of the right to bear arms simply because of their status as felons, or put any virtue-based restrictions on that right.
We are not finished. We are not finished. We are not finished.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
Not one more! Not one more! Not one more!
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
In order to determine whether the historical analogies offered by the Justice Department were appropriate to Section 922G8, Judge Wilson then utilized the historical tradition test outlined in Bruin. The English and American laws that provided for the disarmament of dangerous people, the English and American going armed laws, and the colonial and early state surety laws were the 3 types of potential analogies listed by the Justice Department. The February 2nd opinion claimed that historical laws disarming dangerous classes of people were unlike modern law because the purpose of these dangerousness laws was the preservation of political and social order, not the protection of an identified person from the specific threat posed by another. Judge James C. Ho's expanded concurrence, which was incorporated in the updated March 2nd judgment, said that civil protective orders are too frequently misused as a tactical device in divorce proceedings and issued without any actual threat of danger. Judge Wilson took his argument further, claiming that if a judge had granted a mutual protective order, It could even place domestic violence victims in greater danger than before, because they wouldn't be able to use weapons to defend themselves against their abusers. The Fifth Circuit's dangerous and extreme decision. On February 2, 2023, a three-judge panel of the Federal Fifth Circuit Court of Appeals ruled that the federal prohibition on gun possession for people subject to domestic violence restraining orders, DVROs, is unconstitutional under the Second Amendment.
Conventional wisdom was we would never get any Republicans to support gun legislation, period.
Are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimum.
Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing.
Demonstrating that blind loyalty to Speaker Dade Phelan is more important than upholding their oath of office.
Might end up being a message amendment because the President of the United States will almost assuredly veto it.
For the time being, the opinion affects only 3 states under the purview of the Fifth Circuit: Texas, Louisiana, and Mississippi. The decision is extremely dangerous. If it is not immediately vacated or put on hold and ultimately reversed, it would gut a fundamental public safety law and endanger the lives of domestic violence survivors nationwide. However, the decision is wrongly decided even under the reckless logic of the Supreme Court's Bruin's opinion, and we believe it will eventually be overturned if Bruin is correctly applied on appeal. What happens next in the courts? The United States Department of Justice is responsible for prosecuting Rahimi and will now determine whether to appeal this decision directly to the Supreme Court,
to run enhanced background checks on young people under 21 trying to buy a firearm.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
Or else whether they should ask first the full 16-judge panel on the Fifth Circuit to rehear the case together in bank review. We expect the DOJ will also seek rehearing from the full Fifth Circuit, which, if granted, would likely vacate the panel decision to hold off the dangers of armed abusers during the course of further review. If the DOJ seeks an en banc review and the full court reaches the same decision as the 3-judge panel, it is near certain that the Supreme Court will review the case. Dangerous for women in America. Gun laws that protect victims of domestic violence are among the most important public safety laws in the country and have always been a central focus for every town and the broader GVP movement. An average of 70 women in America are shot and killed by an intimate partner in an average month, and the presence of a gun in a domestic violence situation makes it 5 times as likely that a woman will be slayed. The decision has immediate and drastic practical effects in the 3 Fifth Circuit states. We are hopeful that the panel decision will be vacated while further review proceeds. If not, we are deeply concerned that protections may fall away quickly in Texas, Louisiana, and Missouri, with DVRO subjects no longer being informed they are prohibited under federal law and no longer subject to prosecution for having firearms.
I'm just inspired by the next generation. I think it's a time for a big change.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries.
Selling more guns in the last 3 weeks than we did in the last 8 months.
But for me, and for most of you, here's what it really is. It's an important first step.
When somebody bump fires, think of this as a bump fire stock and able to move.
To be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
Moreover, legal challenges are very likely for state-level laws prohibiting gun possession and requiring firearms. In the worst-case scenario, domestic abusers may even become able to pass a background check at a gun dealer. Note that the 47 states outside the Fifth Circuit are not directly impacted by the decision. The Fifth Circuit panel opinion misapplied Bruin. If Bruin is correctly applied on appeal, we believe the opinion will eventually be overturned and the challenge will ultimately fail. The panel dismissed out of hand the fact that Bruin and Heller had emphasized repeatedly that the Second Amendment protects law-abiding, responsible people. Contrary to Bruin's clear instructions, the panel essentially ruled that the law is unconstitutional because the government did not identify a direct historical twin to the DVRO prohibitor, an identical precedent from early American history. The Fifth Circuit also misunderstood Bruin's direction that courts evaluate whether a gun safety law reflects an unprecedented societal concern, which the DVRO prohibition so clearly does. The panel decision should ultimately be reversed, opening doors to dangerous opinions. In Bruin, the Supreme Court not only struck down an important part of New York's concealed carry law and disapproved similar laws in 5 other states, but it also significantly changed the analysis that all courts must use to evaluate Second Amendment challenges going forward, putting into question hundreds of existing lower court decisions that have upheld core gun laws.
And having to tell her that other 9-year-olds were just killed in a shooting is horrific.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a federal agent.
Get on the ground!
Real background checks could stop a lot of illegal guns going in different places in the country.
Shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
Affect us here, and it was such a breath of fresh air for the Second Amendment people.
It takes extraordinary courage for them to stand up here and retell the story.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
And inviting gun lobby efforts to attack our public safety protections in court. Because of Bruin, everyone in America is now in danger of many more situations like the ones we face after this hazardous Fifth Circuit decision. Again, we do expect that with a correct application of Bruin on further review, the Fifth Circuit will be reversed and our domestic violence laws will be safe. But unless and until the panel decision is vacated and ultimately reversed, survivors of domestic hurt in 3 states will face a life or death crisis where their offenders may have ready access to firearms. The Rahimi decision does not impact every town's ongoing strategy to pass and defend the strongest gun safety protections nationwide, including domestic violence laws. While Bruin did significantly change the analysis that courts must use to evaluate Second Amendment challenges, the gun safety laws every town advocates for remain constitutional even under that analysis. We continue to believe that our core gun laws will be upheld in time, and that the only correct strategy for the GVP movement is to keep up our fight to reduce gun violence. Arming domestic subjects. Zaki Rahimi, a drug dealer in Texas with a history of armed violence, is hardly a model citizen, a federal appeals court judge wrote in March with a considerable understatement. But the court vacated Mr. Rahimi's conviction under a federal law that makes it a crime for people subject to domestic violence orders to possess guns, ruling that the law violated the Second Amendment. Next week, the Supreme Court is set to consider whether to hear an appeal of that decision, which applied a history-based test to rule that the government was powerless to disarm Mr. Rahimi under the domestic violence law. The chances that the justices will agree to hear the case are good. The case started in 2019 when Mr. Rahimi assaulted his girlfriend and threatened to shoot her if she told anyone, leading her to obtain a restraining order. The order suspended Mr. Rahimi's handgun license and prohibited him from possessing firearms.
Blatantly denying the power grab being carried out by the executive branch yet again.
The uptick in violence has just been astronomical. The gun violence.
As a kid, I came out of a different movement, the civil rights movement.
Who showed up here said one thing that felt good about doing this kind of event was that they felt empowered.
Pretty clear about the extent to which this is an abuse of the Administrative Procedures Act.
Is it a difficult question to understand?
Well,
I'm sure it's enormously high.
It's 36 per 100,000 people.
I just felt that I needed to be able to protect myself.
Mr. Rahimi defied the order in flagrant fashion, according to court records. He threatened a different woman with a gun, leading to charges of attacks with a fatal weapon. Then, in the space of 2 months, he opened fire in public 5 times. Upset about a social media post from someone to whom he had sold drugs, for instance, he shot an AR-15 rifle into his former client's home. When a fast food restaurant declined a friend's credit card, he fired several bullets into the air. The shootings led to a search warrant of Mr. Rahimi's home, which uncovered weapons, and he was charged with violating the federal law. After a judge rejected his Second Amendment challenge to the law, he pleaded guilty and was sentenced to more than 6 years in prison. The U.S. Court of Appeals for the Fifth Circuit at first affirmed his conviction in a short decision, rejecting the argument that the law violated the Second Amendment in a footnote. But the appeals reversed course after the Supreme Court issued a decision last June, establishing a new test to decide whether gun control laws are constitutional, one focused on history. Under that test, a unanimous 3-judge panel of the Fifth Circuit ruled the law prohibiting people subject to domestic violence orders from possessing firearms violated the Second Amendment because there was no historical support for it. Almost a year to the day after the Supreme Court announced this new approach in New York State Rifle and Pistol Association versus Bruin, The justices are set to meet to discuss whether to hear the Biden administration's appeal. The court often hears appeals of decisions holding federal laws unconstitutional. The case, United States v. Rahimi No. 22-915, would give the court a chance to explore the scope of its new test, which requires the government to identify historical analogs to justify laws limiting Second Amendment rights.
Because he doesn't care about separation of powers either.
The Texas House of Representatives just voted to impeach Texas Attorney General Ken Paxton.
How many guns has the ATF lost?
I'm not sure I understand the question.
But what is also true is that it is incumbent upon the United States Congress, the House of Representatives in particular.
Twime says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
The extent to which this is an unconstitutional violation of our Second Amendment rights.
As a general matter, Justice Clarence Thomas wrote in his majority opinion in Bruin, the Second Amendment protects the rights of an ordinary, law-abiding citizen. And there is, the Biden administration told the justices in the new case, strong historical evidence supporting the general principle that the government may disarm dangerous individuals. But the Fifth Circuit Court rejected a variety of old laws identified by the government as possible analogs, saying they did not sufficiently resemble the one concerning domestic violence orders. Many of them, Judge Corey T. Wilson wrote for the panel, disarm classes of people considered to be dangerous, specifically including those unwilling to take an oath of allegiance, slaves, and Native Americans. That was different, he wrote, from domestic violence orders, which make case-by-case judgments about a particular individual's dangerousness. Lawyers for the administration questioned that distinction. It would be bizarre, they wrote, if legislators could disarm dangerous individuals based on categorical presumptions, but not based on individualized judicial findings after notice and a hearing. Judge Wilson, who was appointed by President Donald J. Trump, wrote that the government's insistence that it can disarm people who are not law-abiding admits to no true limiting principle. Could speeders be stripped of their right to keep and bear arms, he asked? Political nonconformists, people who do not recycle or drive an electric vehicle? Judge Wilson conceded that the challenge law embodies salutary policy goals meant to protect vulnerable people in our society. But he said the approach required by the Bruin decision did not allow courts to weigh the benefits of the laws against its burdens. What was important, he wrote, quoting that decision, was that our ancestors would never have accepted the law on domestic violence orders. Judge James C. Ho, who was also appointed by President Trump, issued a concurring opinion expressing his belief that there are more effective ways to protect victims of a domestic abuse. In his opinion, he stated that individuals who commit acts of violence, including domestic violence, should not only be disarmed but also detained, prosecuted, convicted, and incarcerated. Judge Ho emphasized that the criminal justice system exists to punish criminals and prevent them from committing further crimes. However, Judge Ho acknowledged that domestic violence orders are products of the civil justice system and can be subject to misuse. He highlighted concerns raised by scholars and judges regarding the potential misuse of civil protective orders as tactical devices in divorce proceedings, often without any actual threat of danger. Due to these concerns, Judge Ho found it challenging to justify the law challenged by Mr. Rahimi, which aimed to disarm individuals deemed dangerous as an appropriate measure. In response to the brief urging the Supreme Court to deny review, Mr. Rahimi's lawyers argued that domestic violence is not a new phenomenon, and pointed out that the founders of the country had the option to implement a complete ban on firearms to address intimate partner violence, but chose not to do so.
I don't really see the purpose of letting other people that don't really know what harm they can do.
You specifically said that.
But I said...
That's the law. What does mandatory mean?
I'm trying to say that...
Does it mean that prosecutors get a choice?
I would expect to see in the coming months and years is a lot of focus on whether or not enough places are deemed sensitive right now.
The Attorney General himself, Ken Paxton, tweeted saying, quote, "What we just witnessed is illegal."
Gun ownership for spouses, Supreme Court decision. Last February, the far-right United States Court of Appeals for the Fifth Circuit held that a federal law prohibiting individuals from possessing a firearm while under a domestic violence restraining order is unconstitutional. On Friday, the Supreme Court announced that it will hear this case. It is fairly likely that the justices will reverse the Fifth Circuit's extraordinary decision, as many as 6 current members of the court have signaled that. While some of them support an expansive reading of the Second Amendment right to bear arms, the Fifth Circuit's decision in United States v. Rahimi goes too far. Justice Brett Kavanaugh has endorsed some prohibitions on gun possession by people who have not been convicted of a felony, including laws prohibiting people with serious mental illnesses from owning guns. Justice Amy Coney Barrett, meanwhile, wrote when she was still a lower court judge that legislatures have the power to prohibit dangerous people from possessing guns. A more uncertain question is whether the court will use the Rahimi case to impose some coherence on the incomprehensible approach to the Second Amendment that it announced just 1 year ago in New York State Rifle and Pistol Association v. Bruen 2022. Bruen held that huge swaths of U.S. gun laws must fall unless the government can prove that the regulation is consistent with this nation's historical tradition of firearm regulation, and instructed judges to determine whether a particular challenge gun law is consistent with this tradition by searching for historical analogies in early American firearm regulations. In practice, however, it is often impossible to draw precise analogies between today's gun laws and those from 2 centuries ago because both American society and firearms technology have changed so much since the Second Amendment was ratified.
Today, we say more than enough. We say more than enough.
No Democrat has ever tried to get anybody's guns. I mean, that's just a lie that they tell, and y'all ought to stop perpetuating the lie.
We can reach compromise on guns. We ought to be able to reach compromise on other critical issues from veterans, health care.
To have their firearms, which are being held by the government, transferred to a third party for the third party to sell.
Atlanta, Buffalo, Uvalde. And for the shootings that happen every day in the streets that are mass shootings we don't even hear about.
Consider, for example, the federal ban on mash guns. The mash gun was not even invented until 1884, so anyone hunting for early American laws banning this kind of weapon will come up blank. That said, Bruen also acknowledged that the United States has a historical tradition of prohibiting the carrying of dangerous and unusual weapons, so a judge who wishes to uphold the mash gun ban could point to this language in Bruen to justify such a decision. Or consider, for that matter, the law at issue in Rahimi, which prohibits many individuals who are subject to a court order that restrains them from harassing, stalking, or threatening an intimate partner from possessing a gun. Notably, this law applies to individuals who have not yet been convicted of a crime, but who have had court proceeding that determine they are a danger to their partner or their partner's children. In defending this law, the Justice Department points to various English, colonial American, and early U.S. laws that disarm people considered to be dangerous. But the DOJ is unable to cite any laws from these eras that specifically prohibit people who abuse their intimate partners from possessing a gun, because no such laws existed at the time. Indeed, it was legal in all 50 states for married partners to beat their spouses until 1871, when the Alabama Supreme Court ruled that a husband and wife may be indicted for assault and battery upon each other. Bruen, in other words, requires judges to weigh gun regulations using a tool, historical analogies, that is wholly unsuited to that task. Asking judges to determine whether any 18th century laws resemble modern-day gun regulations is a bit like asking how James Madison would have regulated smartphones. Early Americans simply did not possess weapons that in any way resembled today's firearms, and we have no idea how they would have regulated more modern weapons. Worse, because Bruen held that in tough cases, the government must demonstrate that a modern gun law is consistent with this nation's historical tradition of firearm regulation, the onus is on the government to find sufficient evidence to defend laws already on the books, rather than on people challenging a regulation. That means that courts are now striking down gun laws that few people would find objectionable because, in the absence of evidence that the framers would have supported a modern-day law, the law typically must be struck down.
So the third party can either keep them in trust or sell them and give the money to Mr. Henderson.
James commented on the decision, saying she's pleased. Remember, the law, as it stands, strengthens requirements.
And in many cases, the value of the firearms can be quite high.
Today, for the most significant law to be passed since then, since the last 30 years.
And prohibits guns in sensitive places and requires background checks on all ammunition purchases.
Statute means what it says. It says that a convicted felon cannot possess a firearm.
I'd like to thank the leaders and members of the House and Senate for working together to get this done. I especially want to thank the families.
It doesn't say he can't sell a firearm that the government is possessing on his behalf.
Bruen is wreaking havoc. In the years since Bruen was decided, federal courts have struck down numerous gun laws, including the ban on domestic offenders possessing firearms that was struck down in Rahimi, that impose fairly modest limits on gun owners. A federal judge in West Virginia, for example, struck down a federal law that prohibits possession of a firearm if the gun's serial number has been filed off or otherwise removed. Judge Joseph Goodwin's opinion in the United States versus Prince acknowledged that this law makes it possible to track firearms, to help keep them out of the hands of individuals whose possession of them would be contrary to the public interest. But he nonetheless concluded that Bruen requires this law to be struck down because the first guns that were marked with serial numbers were not manufactured until the 1860s, and serial numbers were not broadly required for all firearms manufactured and imported in the United States until the passage of the Gun Control Act of 1968. Similarly, a New York federal judge struck down that state's ban on gun possession within houses of worship, claiming that there weren't enough early American laws that similarly protected worshippers from gun violence. And a federal judge in Texas struck down that state's law prohibiting gun sales to people under 21. He essentially rewrote the law to allow 18-year-olds to buy guns, on the grounds that there weren't enough early American laws prohibiting 18 to 20-year-olds from buying guns. Yet while lower court judges have relied on Bruen to sweep away all kinds of gun laws, it is unclear how the justices are likely to react as these cases work their way through the appeals process. Though Justice Brett Kavanaugh joined the majority opinion in Bruen, he also wrote a separate concurring opinion emphasizing that he would still uphold many restrictions on gun use and possession. Among other things, Kavanaugh indicated that he would support licensing requirements for carrying a handgun, as well as laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, bans on dangerous and unusual weapons, and long-standing prohibitions on the possession of firearms by felons and the mentally ill. Kavanaugh's Bruen concurrence was also joined by Chief Justice John Roberts.
Today, for the most significant law to be passed since then, for the last 30 years.
And that's why gun owners wanted the Supreme Court to put the statute on hold. They have now said no.
Obviously, they're gone, but will be an inspiration for us to do more. I'm not going to sign this bill into law.
Strict limits on guns outside of a home. Two Supreme Court justices say the New York law presents some serious questions.
That is looking out and reading all the cases decided by the United States Court of Appeals and state Supreme Courts.
Similarly, as noted earlier, Justice Barrett once claimed that laws prohibiting dangerous people from possessing guns may be allowed. These opinions by Kavanaugh and Barrett should give hope to anyone praying that the Supreme Court will reverse the Fifth Circuit's decision in Rahimi. Perhaps Roberts and Kavanaugh will conclude that a ban on gun possession by domestic offenders is analogous to bans on the possession of firearms by felons and the mentally ill, which both justices have signaled are consistent with U.S. historical tradition. Or perhaps Barrett will conclude that people subject to restraining orders are sufficiently dangerous that the national legislature may prevent them from possessing a firearm. But if this discussion of Bruen's aftermath proves anything, it should be that the fate of American gun laws is likely to come down to individual judges and justices' arbitrary conclusions about which modern laws are sufficiently similar to laws from 2 or 3 centuries ago to justify the modern law's continued existence. Is a place of worship a sensitive place similar enough to a school or a government building to justify a restriction on guns? Is a high school senior with a gun sufficiently dangerous to justify requiring them to wait until they are old enough to buy beer before they can also buy an AR-15? There are no clear-cut answers to these questions, and the court's approach to them is likely to turn less on objective principles of law than on whether John, Brett, and Amy think that a particular gun regulation should be upheld.
Yesterday, I spoke about the Supreme Court's shocking decision.
That is looking out and reading all the cases decided by the United States Court of Appeals and state Supreme Courts.
Strict limits on guns outside of a home. Two Supreme Court justices say the New York law presents some serious questions.
Implemented by states, my administration is going to focus on how they administer it and whether or not they violate other laws.
Saying you can bring a gun in here, you can't go into with a gun.
And that's why gun owners wanted the Supreme Court to put the statute on hold. They have now said no.
Restrictions that New York passed on their statute about where you can have guns, places that don't have a sign.
Before Bruen, federal appeals courts united around a Second Amendment framework that could be fairly easily applied by any competent federal judge. Severe burdens on the right to bear arms, such as a law prohibiting gun possession in the home, were subject to strict scrutiny, an unforgiving but familiar test that most law students are taught in their first year of classes. Meanwhile, less onerous laws were subject to intermediate scrutiny, a more forgiving test that is also taught to law students in their introduction to constitutional law. This familiar framework, which required judges to use tools that they already knew how to use, led to much more predictable outcomes than the chaotic appeal to historical analogies demanded by Bruen. In an ideal world, the court would recognize that its decision in Bruen is a failure that should be overruled. It offers no meaningful guidance to lower court judges trying to decide which gun laws should be struck down. It endangers laws that no sensible person would oppose, such as the law at issue in Rahimi. And it requires judges to ask silly questions like whether a ban on domestic abusers owning guns is sufficiently similar to a 1662 English law, allowing the crown to seize guns from people it determined to be dangerous to the peace of the kingdom. Realistically, a decision overruling Bruen is unlikely, but at the very least, the court could try to use the Rahimi case to rework the Bruen framework so that it no longer produces results that are completely arbitrary. And that's it for this video, folks. We'll see you next time at the next one.